Good afternoon. My name is Elena Shavtsova. I am an immigration attorney from Brooklyn, New York. Today I would like to talk to you about adjustment of status. It's a very large topic and we will not be able to cover all the aspects of it, but I can share with you a few tips. First of all, a person can adjust his status or her status while in the United States to one of a permanent resident if he or she entered the country legally. There are a few very small exceptions to this rule. If the person, one of them, let's say a person adjusting status based on asylum status that he or she previously received, or U visa or VAWA benefit, but most of the time the person must enter the country legally. There is another exception to this rule, is if a petition was filed for the person, a family or employment petition was filed for the person before April 30th, 2001. Then the person might also qualify for adjustment of status even if he or she entered the country without a visa or by crossing the border. Otherwise, the person has to come to the United States via visa or parole. The second rule to adjustment of status is that the person, as a rule, has to maintain legal status in the United States, lawful immigrant status in the United States, through all the time he or she has been in the United States, unless this person, again, falls under one of the exceptions, or the person is marrying a U.S. citizen. In this situation, if the person is marrying a U.S. citizen, this requirement can be waived or forgiven. Third tip: when somebody wants to receive a green card in the United States, he or she, as a rule, must have a sponsor, somebody who will vouch for this person's expenses in the United States, meaning that a prospective green card holder will not be a burden for the government. Affidavit of support should be executed only by a U.S. citizen or permanent resident, and there are guidelines on how much money a sponsor should make to be able to sponsor somebody into the United States. Last tip: if somebody wants to adjust his or her status or receive a green card, they should be legally able to do it, meaning they should not have prior immigration or criminal violation in their record that will prevent them from doing so. And usually an attorney's opinion is needed to determine whether or not the person will be able to get his green card. If, let's say, there is outstanding order of deportation against the person, or the person was in criminal court at some point, even if the charges were dismissed, still, this person will likely be needing an assistance of an attorney to get his or her green card. So those are the main things. You can learn more about it by visiting our website at www.shavtsova.com. Thank you.